Good afternoon, everyone, and welcome to the PACE FCC Declaratory Ruling Briefing. My name is Chris Herrick, and I'm the SVP at PACE. We have a very informative webinar for you today, but before I turn the reins over to PACE's General Counsel Michelle Schuster and Nick Whistler, there are a couple of housekeeping items I wanted to remind you of. First of all of your lines are on mute to cut back on any background noise. So if you have a question, please type it in the chat box on the lower left-hand corner of your screen. And at the end of today's webinar, we'll get to as many questions as we can as possible. Second of all, this webinar is being recorded and will be on the PACE website in a few days for you to access. Third, the slides will be available and we will send them out to you later today. Now with that, I'm going to turn this call over to PACE's General Counsel, Michelle Schuster and Nick Whistler.
Thanks, Chris, and thanks for scheduling this call so we can get this important information out to PACE's members. What is not news is that the FCC's ruling of last Friday has dramatically spun the industry on its head and has changed what we all have known to be the application of the TCPA to our business practices. So I want to emphasize at the beginning of this call that Nick and I will be going through our interpretation of the FCC order, and which is consistent with all of the other associations that are out there that we have been following through this ruling process for the most part. And while we are giving you our interpretation of what the ruling says, to the extent that you can do that because the ruling is about as clear as mud, I will tell you, it's really important that you seek your own competent legal counsel because in a number of places in this FCC ruling, it talks about how things will be determined on a case-by-case basis, and that's certainly not helpful when we're trying to divine a legal principle. But it does mean, for purposes of your own compliance, it is very important that you seek counsel and that you get what we frequently call a defendable position for whatever it is that your business practices are. And Nick and I are available to the extent that there are general questions not specific to a specific business practice. So with that said, let me just give you some overriding observations about the declaratory ruling. And first I want to start by saying that PACE has been very involved in this process from the get-go. After the 2013 order was announced in 2012, on behalf of PACE, we filed a motion for reconsideration of that rulemaking. That has not been in any way addressed by the FCC. We did again in 2013, shortly before the effective date of the ruling, file a petition for a declaratory ruling and, in the alternative, an expedited rulemaking. And let me just explain to you why we did that. We thought it was important that we not give the FCC an out in that we had not requested a rulemaking because we had thought that if the FCC did something like it did last Friday with this very expansive, broad ruling, that they wouldn't be able to do that in a declaratory ruling. And that's because a declaratory ruling in general just says what the statute has always meant. It's the FCC interpreting that. A rulemaking is very different in that it expands on what's in the current TCPA and the rulemakings that the FCC has previously taken. So we were concerned that if we just asked for a declaratory ruling and it went beyond just clarifying the TCPA, they would claim they could not give relief. Having said that, the FCC did rule on our petition as one of the numerous petitions that it ruled on in this declaratory ruling. The PACE petition is cited throughout, cited pretty heavily by the dissents to the ruling. And unfortunately, we were not granted the relief that we requested from the FCC, even the very basic relief that we requested, which was clarification on the definition of what constitutes an ATDS. And to the contrary, I would say we have less clarity now as to what constitutes an ATDS, and that's what we'll spend a substantial portion of today's call talking about. Just by way of history, we filed the petitions, as I mentioned, starting back in 2012, and then again in 2013. The FCC was largely silent until May 27th when Chairman Wheeler put out a fact sheet that outlined in a very brief one-page summary what the FCC was intending to do with its rulemaking. It's an unusual move that the FCC would have done that, but nonetheless, that was the first notice that the petitions were going to be responded to in the form of a declaratory ruling. It also announced that on July 18th, there would be an open meeting on which the Commission would be voting on a proposed declaratory ruling. That July 18th open meeting, I'm sure many of you on this phone sat through, as did Nick and I. It was interesting for a number of different reasons, mostly because it is obvious that there is a pretty large split within the FCC, and it's along party lines, and that the Republicans who were in the minority were pretty unhappy about the process of getting to this declaratory ruling, and also did not vote to approve the declaratory ruling and or the dissents to the ruling. Nonetheless, the declaratory ruling passed on the 18th. The FCC took several weeks, mostly to clear up, it seems like, editing and non-substantive issues, and then the ruling was finally released at after 5 o'clock on Friday, July 10th. We've spent a considerable amount of time reviewing, as I said, the ruling, and what follows is our take on what the FCC did in that July 10th declaratory ruling. The slides that we have prepared, we will make available to you after this presentation, and Chris Herrick will provide directions on how you can obtain those slides. The slides are very basic in that they provide a high-level overview of what the declaratory ruling says, but hopefully it'll give you something of a guide as you're reading through the ruling of what we thought were the high points of that. If you have not gotten a copy of the FCC's declaratory ruling, and I highly recommend that you do get a copy if this affects you, and that you read it from front to back at least once, probably going to take a couple of times, because I will tell you the declaratory ruling is very difficult to understand, mostly because of internal inconsistencies within the ruling. But I still think it's important that you read it and you understand what the FCC has said here through its own color commentary in the declaratory ruling. You can obtain this by going to fcc.gov. On the front page of their website, they have recent events. And last I checked, the July 10th declaratory ruling is still on that first page. If you click that, it'll provide you a link to the declaratory ruling, which can be downloaded or printed. And I encourage you to do that. So with that said, let's get started.
One other thing I wanted to mention real quick is that in addition to these slides, we're also working on putting together a more written statement in terms of what the ruling says, what it means, with some quotes, et cetera. So that should go out in the next couple of days probably. So you'll have that as a resource as well to just kind of give you a high-level overview of what's in that lengthy ruling. So probably the primary thing that most people are concerned about with the ruling relates to their adopted definition of ATDS, or the supposed clarity they gave to what that definition means. At a very high level, what we're talking about is the statutory definition says it is equipment that has certain types of capacities, and the FCC hasn't always aligned with the actual statute in terms of what those capacities are. But above and beyond that, there was some disagreement over what the term capacity in and of itself means. And PACE, along with several other associations, companies, had asked for clarity that what capacity means is what the equipment can do right now, not what it could do if you modify it, not what it could do, theoretically, et cetera. And that just made common sense. It aligns with the statute. There's lots of good reasons for that. It comported with some of the court opinions that have been out there, et cetera. So that was the ask. Unfortunately, the FCC went the opposite direction. They rejected any argument that equipment could not be an ATDS merely because it didn't have present capacity to perform the functions outlined in the statute. Basically what they said is that if it had the potential capacity to be an ATDS, it is an ATDS. And the one specific example that they gave, and pretty much the only example that they gave, was that if you had a piece of equipment that could have certain capabilities, if you downloaded software to it, then it would be deemed to have those capabilities when determining whether it was an ATDS. So it's not just what the software on the system could do right now, but what it would be able to do if you downloaded that software. As you can imagine, that's a pretty troubling standard. They did say that the definition of capacity is not unlimited, and what they said is that just because you could theoretically modify something doesn't make it an ATDS. The problem, though, is that they gave us very little clarity in the difference between what is potential capacity that would make it an ATDS versus theoretical capacity, which would not. And in fact, the only example that they gave us was that a rotary phone, even though, maybe theoretically you could modify that, that's not sufficient. That's too attenuated. So, on one side you have, if you can download software, it's an ATDS. On the other side, if it's a rotary phone, it's not. And everything in between is kind of subject to interpretation and to some of the other commentary made in the ruling. One of the examples that the dissent pointed out that Michelle's probably going to talk about more here in a second was raised by the dissent, and they said that when you talk about capacity, you're talking about what it can do. You would never say that a 80,000-seat stadium could hold 104,000 seats. And the majority said, well, that's ridiculous because, that involves all this work and all this money, and that's theoretical. That's not potential. So, again, very little clarity. I don't know that that helps us much, but we do know that if there's a certain amount of time, effort, money, et cetera, required to get from point A to point B, your argument that that's more theoretical capacity versus present capacity is stronger. But other than that, we're really just kind of formulating our own positions and trying to make the best arguments that we can. The other interesting aspect is that we had asked them to confirm that, among other things, it had to have the capacity to dial without human intervention. So that was the standard that they enunciated regarding predictive dialers. We don't think that that's a correct standard, but we wanted to at least have them confirm that if it can't dial without human intervention, it can't be an ATDS under any circumstance. And they basically rejected that on the same ground, saying that you really need to look at the potential capacity, not its current capacity. Other comments that they made is that you can't get around the TCPA by dividing up ownership. So if you've got one piece of hardware that has the list of numbers, you're using another piece of hardware or software to actually dial the numbers, and even if those are divided amongst different entities, you still can't get around the definition by doing that. But one of the biggest problems is that they specifically said in there that they're not going to define the exact contours of the definition, which is kind of the problem I've been mentioning. They give you a couple examples, very unclear examples, and then they say we're not going to address this specific definition or address all the different types of equipment that might be out there. They reiterated some of their prior rulings, so they reiterated that a predictive dialer is an ATDS. They reiterated a 1992 holding that said speed dialing in and of itself is not an ATDS. Just because you have that capacity doesn't make it an ATDS. That's nothing new. And then they interestingly cited that the basic function of an ATDS is to be able to dial without human intervention, which was very interesting because not one or two paragraphs before that they had rejected that as being a requisite to the definition. So that's one of the internal inconsistencies that Michelle mentioned earlier. The other thing that we've always mentioned is if you adopted this very broad potential or future capacity standard, that basically means everything could potentially be modified. I mean, every smartphone, every computer, everything that has some type of processor, some type of CPU could be considered an ATDS, and they kind of just brushed it off and said, well, you say that a smartphone might be an ATDS, and maybe that is or isn't the case, but we don't see anything in the record that shows people are getting sued for using their cell phones to call other cell phones. something that the dissent took issue with, but basically they just brushed that off and didn't address it at all. So that's kind of what they said. Their underlying rationales mostly are flawed, but they said that Congress intended the definition to be broad and that this best accomplishes that. They said that they had authority to adapt the interpretation based on new technologies. They said that it was consistent with their prior rulings, which I completely take issue with, and even the dissent says is completely inaccurate. They seem to be concerned with the fact that if it was a present capacity standard, it'd be difficult to enforce, and that it would mean that virtually no equipment would be an ATDS, and they were concerned that at that point the statute would, have no teeth, basically.
And I'll tell you, I'm going to be talking about the dissent's interpretation of what Nick's talking about right now, because I think the dissent is important for at least providing some contours of clarity with regard to this ruling. But, it's very interesting that throughout this ruling, the FCC sided with and implied that legitimate business is a bad actor consistently throughout. In emphasizing its consumer protections, that was the rationale that it used. And obviously all of us on this phone call that are legitimate businesses that are attempting to do that right would take issue and will take issue with that position.
So that's at a high level. Basically what they said about an ATDS, as Michelle said, there's a bunch of commentary in the dissents that she's going to go through, and I think you'll see that their position aligns much more closely with our position, with what Pace had advocated for, and what we'll be arguing potentially on appeal. But by and large, that's what the majority standard was, and those are the rationales that they gave for that. Again, not a lot of clarity, probably more questions than answers, quite frankly, but nonetheless, that's what's in the ruling.
So, the dissent is actually you might actually get a little bit of enjoyment, although you won't out of the rest of this ruling from reading the dissent. The Republican commissioners, Pai and O'Reilly, went through and set forth a framework for why the original order is flawed, and in providing some examples, helped us, I think, to provide some constraints for what the majority's opinion is talking about. And I think that that stadium analogy that Nick was talking about is a good example of that. They were specifically talking about Lambeau Field and that it's got an 80,000 seat capacity and it couldn't hold 102 people, although theoretically they could do something to modify the stadium to make it fit that 102. And as Nick said, the majority opinion said that was hogwash, because obviously you'd have to make some structural changes and expense. So we point out the dissent because, like that analogy, it does give us some contours where maybe we can find some outer limits to what the FCC would interpret as an ATDS. So that's why we're spending some time to go through here and talk a little bit about the dissents. First I just want to say that the dissents, in talking about the majority opinion, they say that the FCC has strayed pretty far afield from what, in its interpretation of what the TCPA was originally intended to do. The dissent points out that the FCC has always had within its power to take aggressive enforcement action against violators and has chose not to take that position, but rather here is penalizing legitimate businesses in its decision. It also says that it could have provided a safe harbor for legitimate businesses that are attempting to comply with this law, and again points to the fact that the majority opinion did not do that. In talking about what Nick has just gone through with what constitutes an ATDS from the majority's opinion, I will tell you that this is the issue that really is at the heart of what Pace is very concerned about. It was at the heart of our petition, and I'm getting a number of questions being asked about whether Pace intends to appeal the declaratory ruling, and I can tell you that yes, Pace is appealing the declaratory ruling. We anticipate that petition for review is what it will be called, a petition for review, will be filed within the week, is our intention. We have 60 days to file it, but out of an abundance of caution and so that we can be involved in what's considered a lottery for which circuit will hear this appeal, we'll be filing within the first 10 days, and that 10-day clock we're starting on July 10th. So that answers, I know, some of the questions that we have over in the window. You know, in the in the dissent, they really focus on what the TCPA says, and it says that there is a statutory definition of what constitutes an ATDS. There's some lack of clarity around the word capacity, but that all in all, the FCC is required to follow what the congressional intent is, and if there is a specific definition within the statute, then that's what the FCC should be required to file. That will certainly be a basis for the appeal that we'll be filing. As Nick pointed out there, and the dissent pointed out, there are a number of internal consistencies within this document. One of my favorite internal inconsistencies is that we have this very unclear definition of what constitutes an ATDS, but then later when talking about reassigned numbers, the order says that companies have the ability to manually dial telephone numbers to determine if they're calling the right phone number, and it's just ludicrous that that's the approach that they would take. Also, like this stadium analogy that we were talking about, the dissent also uses the analogy if you have a 1-gallon bucket, it doesn't have the potential to hold 2 gallons, and also just talking about the outer construct of what a definition could be, meaning that you can't have to change that type of physical presence of the object. So one of the things that both dissents are very clear about is they feel that the declaratory ruling is unconstitutional. And one of the reasons that they cite for the unconstitutionality of the decision is that, as Nick said, the ruling says that basically any smartphone has the ability to be an ATDS. And that means that any phone call that's made because the TCPA applies to any phone call, not just telemarketing calls or commercial calls, which don't have the same constitutional protection under the First Amendment as all speech does. But with its very far reading of what constitutes an ATDS to include a smartphone, it has chilled all speech through cell phones, through smartphones, from one person to another where there hasn't been express consent for just even informational type calls. So I would imagine that will be a strong argument as this declaratory ruling is being appealed. Also, the dissent points out, and I think it's a very valid point, that the majority said that unless they have this definition, this very expansive definition of what constitutes an ATDS, then no modern equipment is an ATDS. And the dissent in response to that said, well, that's wonderful. If the TCPA set out to eliminate random and sequential dialing, and as a result of the TCPA and how companies have reacted to that, we've eliminated random and sequentially dialing, then the TCPA has accomplished its goal. Also, as Nick's already talked about with the human intervention, Commissioner O'Reilly talked about the fact that it's even more unclear now about how human intervention and what's de minimis, non-de minimis human intervention is under the majority's reading of the order, the TCPA.
All right, so that was an overview of the ATDS issue. Again, probably the most important and most problematic issue. I think number 2 on that list is probably calls to reassigned numbers. So many companies and associations have been seeking clarity that the TCPA does not impose liability when you think you have written consent and you have a reasonable basis to believe that, or just prior consent, I guess, for a non-marketing call. If you think you have consent and you don't know that a number has been reassigned to somebody else, so you end up reaching somebody else, but you didn't realize that the number had been reassigned. The FCC basically declined to provide any workable interpretation or safe harbor. As far as an interpretation, they said you need the consent of the called party, and the called party is the actual or the current subscriber of the phone number or its customary user. So that would be in the context of, a family plan or something like that where you have one subscriber but then another user of the phone. They said that they recognized barely that there's no definitive list to scrub against to determine if a number's been reassigned, so that they provided what they deemed to be a safe harbor, a one-call safe harbor for number to calls to reassign numbers. For that to apply, they said that you had to have had prior consent. You had to have consent of the prior subscriber and no knowledge that the number had been reassigned. So if you could establish those two elements, you would apply for this one-call safe harbor. The biggest issue is that it provides no requirement for that one call to give the caller any type of knowledge that the number had been reassigned. So it's not one call once you are put on notice by, for example, somebody saying that that's a wrong number, or that person isn't at that number, etc. Then you would be put on notice, and the safe harbor wouldn't apply. That is not what it does. It gives you one call. That's it. And they go so far as to say that call gives you either actual knowledge or constructive knowledge that the number has been reassigned. They also said that there is no requirement for that party to notify you if you do reach them that the number's been reassigned. And the reason that that's important is a lot of these professional plaintiffs, a lot of the individuals that become lead plaintiffs for a class action just let the calls rack up because it's a per-call violation, and then they sue. So they said that there's no duty for them to actually tell you that it's been reassigned, and there's no bad faith defense, even if you could prove that they, in fact, intentionally let the damages rack up. The other thing that they mentioned is that, well, even though there's no definitive list, there are some best practices that businesses can use to, by and large, comply with the standard. They say that there are available databases. Yes, they're not perfect, but they could help. They say that you could listen for disconnected tones or voicemail to determine, hey, that number doesn't belong to that person anymore. As Michelle mentioned, they say, well, you can manually dial the numbers. It doesn't prohibit all calling, just calls using an ATDS. Well, great. That does us no good when there's virtually no clarity on what is an ATDS, and you've adopted this ridiculously broad standard. And then they've also advocated for certain procedures to update contact info, asking people during calls or even sending emails or mails to them. So basically transforming the annoyance from a call to, a bunch of spam emails. So interesting suggestions. But by far the most outrageous thing in the ruling is that they say there's no reason why you can't, as a business, contractually require your customer to notify you when they give that number up. And if you fail to do that as a customer, then the business could sue you or take legal action against you. So this entire ruling, which is hailed as a consumer protection initiative, this big win for consumers, yet within the document, they're setting up a scenario in which they're advocating for businesses suing a customer simply because they didn't give them an updated number. It's pretty incredible.
And again, just to kind of give you an overview of what the dissent had to say, because I'm sure it's what everyone is kind of screaming in their head right now, that this one call safe harbor is fake relief. It's not providing relief for anybody. It doesn't put the calling party on notice that a number has been reassigned. And in fact, litigious consumers have motivation to not respond to those first calls or even the first 20 calls to let the calling party know that the number has been reassigned. So the calling party really has no notice that the number has been reassigned. The interesting thing here is that the FCC is the plenary authority over all phone numbers. So, a good solution here would be for the FCC to put together a reassigned number list against which we could all scrub. Unfortunately, that's not what the FCC did, nor did it give any type of bad actor defense to calling parties for reassigned numbers. So this reassigned number is a big issue. Our friends at the ACA have been seeking relief around this issue for quite some time, and The ACA has already filed their appeal, and this is a large part of what they are appealing. So this is definitely an issue that will be addressed again soon.
All right, so the third topic addressed by the Commission had to do with revoking consent. There had been some arguments in the courts and some petitions presented to the FCC that, number one, you can't revoke consent under the TCPA, certainly not for non-telemarketing calls, or that you should be allowed to control the means in which somebody can revoke consent. For example, by sending an email to a certain address, or just kind of control the channel in which they can revoke consent. The FCC rejected both of those arguments, finding that consent can be revoked at any time and through what they deem to be any reasonable means. The order specifies that could be oral or in writing, so it could be over the phone, it could be via email, etc. They even say that you could revoke it at an in-store bill payment location, which, as you can imagine, could be problematic. But most importantly, they provided no guidance on what they deem to be an unreasonable method. So there's no guidance in terms of a method in which the consumer could attempt to revoke consent, but that would be ineffective. They also said that you can't limit it, you can't force them to use a specific medium, and that it's up to the business to keep customer records to show that they had consent for the call at the time the call was made and that it hadn't been revoked. So you're kind of left in that position of the burden of proof being on the business to prove consent, which has always been the case, but proving that somebody hasn't revoked it is a little bit more challenging.
So as Nick said, compliance with this reassigned number issue is going to be a difficult thing. On the one hand, we're not absolutely certain from what the FCC has said is an ATDS, and it will be a case-by-case basis. So manually dialing is going to be, oh, I'm sorry, did I go the wrong way? I did. I'm sorry, we're on revocation of consent. I apologize for that. So in talking about the revocation of consent, if you were listening to the hearing on the 18th, Commissioner Pai used the example of somebody going into a McDonald's restaurant during busy lunch hour and saying that I don't want you to call me anymore to a harried clerk who's taking hamburger orders, and that could effectively revoke consent, and that could be a reasonable means. So this is going to be a very difficult thing if that's the standard for companies to be able to comply with. I highly recommend that training occur for employees within companies that are in contact with customers or consumers so that they're aware of this requirement, and more particularly that they're aware that if they receive some type of statement that they don't want to be called or contacted, that somehow get to a company database so that revocation of consent can be noted. It's interesting that Commissioner O'Reilly just thinks from the get-go that there is no right to revoke consent at all in the TCPA, and the reason he feels that way is that there is no statutory provision in the TCPA for the revocation of consent, and he says that under statutory interpretation, if Congress had intended to allow consumers the ability to revoke consent, that most certainly would have been contained within the TCPA. So he starts from the get-go that it's not something that is allowed and that the statute was intentionally silent. He then goes on to cite other statutes that do have specific revocation processes for companies that no longer want to receive such things as faxes and other types of consumer protection laws like that. It's going to be a difficult, the dissent points out that this will be difficult for companies because now we're placed in a he said, she said situation, and I can tell you that in a number of cases, the plaintiffs say that they provided oral revocation of consent, and that is a difficult fact to deal with for defense if that wasn't somehow recorded on a telephone call. So now by encouraging consumers to make revocation in any, in quotes, reasonable means, that will be more difficult for companies to deal with. And again, I think right now the only the only way that you have of dealing with those outer echelon, not during a call where it can be recorded somehow and a call disposition or something of that nature, or written revocation of consent. The only way to handle that is training employees and setting up a mechanism to record those types of revocations of consent.
So I think we can go through some of these next issues rather quickly in the interest of making sure we have time for questions, but they reiterated that a text message is considered a call under the TCPA. They had already held that. Courts have largely deferred to that, so they reiterated that. The new aspect of text messages that they addressed, I think for the first time, was that not only did it apply to SMS text, but it also applies to an internet-to-phone text. So, sending a message to the phone number at an email address would also be subject to the TCPA, and they give their rationale for that. And largely that Congress gave them the authority to adopt based on new technologies, et cetera, et cetera. But for the first time, they specifically addressed a internet-to-phone text message, finding that it's covered by the TCPA.
The dissent was pretty clear here. O'Reilly believes that text messages weren't covered because when the TCPA was written, text messages didn't exist, and they shouldn't try to shoehorn this regulation to include text. So I don't know that I necessarily agree with that. And I think the FCC does have the ability somewhat of an ability to deal with certain types of changes in technology, but nonetheless, that was O'Reilly's position. Commissioner Pai just concurred that the TCPA covers text messages. I don't think there's much room for argument around that.
Probably one of the few actual good portions of the ruling related to a one-time on-demand text. Basically what they said was if you have an advertisement and it has a call to action for a consumer to send in a text to get a one-time text. An example I think that they gave was like a coupon. So you're a retail store and you're saying text this to this number, and you could respond with the requested coupon, for example, and that would not be subject to the TCPA. Interestingly, they said the reason it wasn't is because it's a telemarketing text, and I guess that they're saying that by texting you, they're giving you prior consent, even if it doesn't meet the written consent standard. The criteria that they listed are that it has to be requested by the consumer, it has to be sent immediately, so there can't be a delay between when they request it and when it's actually sent, and that it can't contain any additional marketing info. So if you're saying that you're going to send them a coupon and they ask you for that coupon, that's all you can send them. You can't have additional information in that text. Very limited win, but I guess with everything else piling up, it was probably one of the few things that was actually positive. The other topic that they talked about is who is the maker of a call. So who could be held liable for a call or a text. Basically, they pointed you back to the Dish Network ruling that had previously been released. They said that if you physically place the call or text, you are the initiator or the maker and can be held liable. But then they also keep referring to this concept of if you're so involved in the placing of a call, you'll be deemed to have initiated it yourself. And they give some factors. They don't give the exact definition of what would cross the line to be so involved as to if you placed it. The petitions that were before them asked them specifically about certain apps and certain functions. So they said, for example, that UMail has an auto-reply function that's set up by the customer. The customer decides, I want to be forwarded a text anytime this happens, and this is the content of that. They said that they are not an initiator if they facilitate that text message. They similarly said that Glide would not be the initiator if it allowed others to click a button to invite their friends to use the app, even if they gave them suggested language, because it's the user that's initiating those texts. The only thing that they really kind of went against these apps was Glide apparently had some type of function where when you downloaded it, it would automatically send an invite to everybody in your contact list. And they said at that point in time, the app is initiating those text messages, not the user, and therefore it's the maker of the call. probably more relevant and more concerning and worth discussing, though, is their brief discussion on service providers. And they basically said that when you're considering whether these service providers can be held liable for a call, you would need to consider the extent to which, for example, somebody provides a service that is used for fraudulent spoofing or caller ID, or that can be used to block numbers. So the extent to which you're willfully enabling that type of conduct, or even turning a blind eye, for example, that could be problematic. And similarly, if you're providing a calling platform that you have reason to know is being used for an unlawful purpose, you could also be held liable potentially. Again, those weren't bright line rules, they're just factors, but I do think it highlights something that we've talked about for a long time, which is good due diligence policies and procedures on companies that you're doing business with, either as a vendor of yours or if you're a technology vendor for the end users that are using your product, and making sure that you're not just turning a blind eye knowing that they're sending out, for example, millions and millions of pre-recorded messages.
So some of the other kind of outlying issues contained within the ruling, one of those is written consent. And we've long, in the October 2013 rule, the FCC said that in order to have valid prior express written consent, you must disclose that a call is being made with an auto dialer, and you must also disclose that the consent is not a condition of purchase. And it's really that latter one that I think folks were kind of questioning whether that's truly what they intended, because the language was not very clear in that 2013 rulemaking order. But the FCC clarifies here that both of those disclosures are required. This was somewhat problematic, and as a result, a number of petitions for declaratory ruling were filed, particularly in the text message service providers setting. And in response to their requests for clarification and to be exempt from those requirements, the FCC is giving the petitioners, and only the petitioners, there were 3 or 4 folks that petitioned for declaratory ruling on this, but they're granting those petitioners a retroactive waiver from those 2013 requirements that I just mentioned, and they have 89 days in which to get proper express written consent in order to send those text messages. There was no waiver that was given to any non-petitioners with regard to this express written consent requirement.
So just to be clear, it's not that they're saying that none of these petitioners need written consent. The argument was, well, we already obtained written consent prior to that date. We just didn't have those disclosures in there. Clearly, you didn't mean that we needed to get written consent again that had those disclosures, and the FCC said no.
Be careful what you ask for clarification
Yeah, they
around.
said no, actually you did need that. Any call or text sent after that date needs these things, but we think our order was kind of unclear, and we'll give you this waiver for you and your members. So really this only impacts people that did have had some type of written consent prior to that October 16th date from 2 years ago. Anybody that's obtaining written consent now, you do need to have this in there, and there is no waiver that would protect you for not having proper consent at this point.
The FCC, when it was providing what it thought was wins for businesses, talked about the limited exemptions that would apply in the financial institutions setting and also in the healthcare setting. And they gave limited exemptions to calls by those industries with a number of qualifications attached to that. The limited exemption requirements are basically the same. They're a little bit different with regard for describing the specific purpose of the call and the number of calls that you can make. But the next 2 slides summarize what the requirements are in order to take advantage of that limited exemption. For financial calls, those calls have to be free to the end user. The call is to a cell phone number provided by the customer. The name and contact information of the company must be provided in the call or in the text message. And there's specific limited purposes for which they can make these types of calls. And specifically, they point to fraud alerts and data breaches. Those messages have to be concise, 1 minute or less than 160 characters for text. You can't make any more than 3 calls or 3 texts over a 3-day period per event, so per breach or per fraud alert. You have to provide an automated opt-out method, and you have to honor opt-outs immediately. The requirements for healthcare providers are largely the same. The difference pointing out there is that it's limited to specific purposes, appointment reminders, wellness checkups, pre-registration instructions, prescription notices, those types of things that they consider to be important communications to patients and those receiving health care. It has to be concise, again, 1 minute or 160 characters for text, less than 160 characters. And for health care, it can only be 1 call or text per day, and that's 3 calls at a max per week. So those are the limited exceptions that were provided in the ruling. Some other miscellaneous items contained within the ruling. The FCC denied a request for clarification that ATDS rules don't apply to non-telemarketing calls made using a predictive dialer. They also reaffirmed the prior express consent ruling, and that's where if a called party has provided their cellular telephone number as a means of being contacted, and they haven't given contrary instructions about being called or made some type of do not call request, that you can rely on that as express consent to call a person using an ATDS. I will point out, and I know...
We should probably point out that's non-telemarketing calls, just to be clear.
Yes, I'm sorry. And, one of the things that we've talked about in the past is a Walgreens decision that's out there that highlights that if you put any conditions on why you're collecting that cellular telephone number, that would limit the consent that you would have to make those telephone calls. In that Walgreens example, the pharmacists were telling consumers that the reason the telephone number was being collected was to be able to identify somebody if there were 2 prescribers with the same name, so they would then default to cell phone number. And in that case, the court found that because there had been limits put on why that number was being collected, that there wasn't prior express consent to call cell phones using an ATDS. The other item that much discussion was made of during the hearing was that the FCC now makes it clear that telecom carriers and VoIP providers can implement technology that would allow a consumer to block robocalls or to block other types of unwanted calls. So with that, I know we have a number of questions here, and we'll try to get as many of those as we can in the remaining time. We're happy to stay on for an extra 10 or 15 minutes. Let's see what we've got here.
I can go ahead and take them for you, Michelle, so that you and Nick can just answer them.
You know what? It might be easier if I do it, Chris, if you don't mind.
Okay, I have a specific one that came to me that I'll read to you first, though. It said, please explain exactly how robocall is defined legally and if the ruling lumps in robocalling with auto-dialed calls, even if it's not a pre-recorded call.
Actually, didn't give us a definition of robocall.
No, that's actually a really astute question because we always talk about, they always use the term robocall, which is not in the statute, it's not in the regulations, it's a completely made-up word. They seem to use it to include both pre-recorded messages and auto-dialed calls made from an ATDS.
Yep.
But the statute and the regulations have distinct, definitions for those terms, and in certain cases, distinct rules for those. So whenever they try to lump them together, we always say that that's problematic, but there is no definition for robocall.
We have a question about whether the effective date of the declaratory ruling is impacted by the requirement to file in the Federal Register. To be quite honest with you, I don't know the answer to that. This is such an unusual ruling, this type of omnibus ruling. Generally, the effective date for triggering things like time period for appeal starts with the publishing in the Federal Registry of the ruling. We will not be taking any chances, and out of an abundance of caution, we are using the July 10th date as the date that starts triggering appellate rights. I'm not in any way implying, though, that that is the correct interpretation. I could just tell you that we are taking the most conservative interpretation.
And I can weigh in and say that we talked to other practitioners, and they had similar thoughts, and that they were moving forward under the impression that it was effective immediately upon release rather than being published in the Federal Register.
Somebody comments that challenges should go back to prior ruling on predictive dialer being an ATDS, which itself was a big departure from the statutory language. I will tell you the dissent does point that out. In that ruling, they say eliminated altogether the element of randomness of dialing. So we agree with that. And to the extent that we have the ability to do that on the appeal, I'm sure that that's something that we'll be addressing. Somebody asked, what is the effect on preview dialing?
Yeah, I mean, I think that's probably the question we get most often. And again, you know, prior to this ruling, we would have said that if you're using equipment that doesn't have the capacity to manually or to auto dial, doesn't have any functionality other than that preview dialing, the manually initiated calls, that you're outside the definition. So now, according to the ruling, you'd have to look at what equipment is being used to preview dial and determine whether that equipment has the potential capacity to function as an auto dialer. And again, they provided some limited examples of how you might look at that, but very little clarity in terms of what is potential capacity. But that's what it would come down to.
Someone asked how the ruling affects political or charitable calls. To the extent that calls are being made to cell phones and to the extent that there's the potential for calling a number that's been reassigned, this would affect those types of calls. The TCPA's prohibitions against using an ATDS to call cell phones applies to any call, not just telemarketing calls. As we've pointed out during our discussion over the last hour, if you are calling for non-telemarketing purposes, then you are only required to have prior express consent, which is the standard that the called party has provided their cell phone number with no limits on that consent, and that no contrary instructions or do not call requests have been made. You would be concerned in that area also with the reassigned number issue. If a number that you're calling you've gotten prior express consent from the prior cell phone subscriber, then you would have liability after that first call for any telephone calls to that reassigned number.
Right, and just weighing in there, so the standard of what's required in terms of if you use an ATDS for those types of calls, the standard is the same as it always was. It has been prior express consent and remains prior express consent. The only thing that's going to change is if you don't have that and you know you don't have that, what can you use to make those calls? You know, what was the definition of ATDS previously and how is it being interpreted now? And so it may narrow the type of equipment that you can use to make the calls if you don't have that level of consent. But if you do have that consent, it's not going to impact it outside those reassigned number issues that Michelle mentioned.
Somebody asked how revocation of consent is different from a do-not-call request. A do-not-call request is generally what we call a company-specific or an internal do-not-call request. Even prior to the do-not-call laws, companies were required to maintain those company-specific or internal do-not-call lists. So when we say do-not-call request, that's what we're talking about. Revocation of consent is slightly different than that because we're talking about the consent that a called party gives to a company to call them on their wireless telephone. And you can say, don't call me on my cell phone anymore without making an outright do-not-call request. So that, well, that was probably not a good example. By saying that you revoke your consent to be called on a wireless cell phone, then you're revoking your consent. So it's different from an all-out don't call me ever to a don't call me on my cell phone.
Or another example might be, for example, somebody says, you know, I don't want any more of these sales calls at this number. You would have to put them on your do not call list for purposes of complying with that, but you could still make a non-sales call to them because they haven't revoked that consent. Now, practically speaking, though, most companies aren't going to have that level of specificity in their records. So if somebody's asking not to receive calls, typically they're just putting them on their do not call list. So procedurally, the best way to handle that probably is, if you're calling cell phones and you're using an ATDS, you probably need to scrub at least the cell phone portion of your calling list against your internal do not call list. So not exactly the same, but there is a lot of overlap there, and unless you're very specific in terms of your records, you may need to treat them basically the same for calls to cell phones.
Someone asks, are there any federal circuit courts that have adopted the present capacity standard? If so, will the FCC ruling trump these circuit court decisions?
No circuit courts have taken a specific position on present or future capacity. Number of district courts have, obviously, and those have been largely favorable, with one notable exception, but no circuit court has specifically addressed that. That's obviously something that will be at the heart of any appeal of this order, though. And those appeals, by the way, just for those of you that aren't familiar, do go directly to the circuit courts. So the appeal is filed in a circuit court, and that's a way to get clarity from a circuit court on that issue, and hopefully get the order invalidated.
If a consumer provides a cell phone number on an insurance application, the FCC said that would constitute prior express consent, and the company would call that cell phone number for informational purposes, i.e. care coordination, enrollment reminders, etc. I
would say that I think the premise there is largely correct. If somebody provides you their phone number and it's just a general contact number, there's no instructions limiting how it will be used, etc., that meets that lower level of consent for a non-marketing call. But I would just caution anybody to be very careful about how they're categorizing their campaigns, and make sure that you feel comfortable that this is a non-marketing campaign, because anything that was considered a dual-purpose call, for example, would be deemed a telemarketing call. So, the example given here was, I think, some type of reminder. Certain types of reminders regarding, something that's not a reminder to make a new purchase might be considered informational, but anything that has a sales purpose could be problematic. So be very careful how you're categorizing those.
Do you know the list of folks that the petitioners for obtaining consent? Do you have that list? I don't have that list in front of me. Somebody's asking me who's considered. You know what? If you pull the ruling, the list of those petitioners.
The DMA was one. I don't know who all of them are.
Yeah. And they specifically asked, does this include the DMA as a petitioner?
Yep, okay. The DMA was one of the ones that petitioned for the grandfathering in of the old written consent. So the ruling said it applied to the petitioners and their members, so it would apply to DMA members. I don't know who else is on that list of petitioners. That's something that we'd have to look up.
Someone asks, what if a customer asks for you to call them back on a different number, and that number is their cell phone number? By making that call, are you out of compliance? So, that's an interesting question. If that call is a telemarketing call and you don't explain to them that you'll be calling them back using an auto dialer, and that their consent's not a requirement for purchase, then you would be out of compliance. If it's an informational call, if it's not a telemarketing call, and they tell you to call them on a different number, and that's a cell phone number, then that would be express consent, even under the new ruling.
It's probably a good time as any to remind everybody that you also need to be able to prove that. So, if somebody's asking you to call them, is that documented somewhere, and how do you prove that they provided that consent? Because it's the burden of the caller to prove the exemption.
A lot of questions ask about specific dialing solutions. That's really outside of what we're able to address today on the call. Again, I would ask you to consult with competent legal counsel with those types of questions. I think we've gotten most of the calls. Chris, or most of the questions. Chris, were there any other questions that you had or that you've received that you think we need to address at this point?
Kent just did a follow-up to the DMA question. So if you're not a member of the DMA or any of those folks, then would you just be out of luck at that point?
Yeah, as far as that very limited issue, and I think it most specifically deals with text messaging is where primarily that issue was brought up. The question is, and I don't have an answer to this, I wonder if you join the DMA now, if that's... Not that we're putting in a plug for joining the DMA, but it's a wonderful organization.
Yeah, it was interesting because a similar type of question came up about fax rules not that long ago. There's some confusion about a ruling that they released or an order that they released related to faxes, and later they came back and said, okay, we see how there might have been some confusion. No, that's not what the rule means. It means this, but we'll grant a waiver for everybody that had petitioned us for this. But not only did they do that, they actually opened it up and allowed anybody else to submit a waiver request. And after they opened it up, a lot of companies did that. So it's interesting that they did not open it up this time. I don't know if that was intentional or if that was just an omission, but there was no specific commentary or language in there that did open it up, unlike the fax ruling.
The only other one, I saw a couple related to this. If I don't call cell phones or DNC numbers, would I be in compliance with the law?
If I don't call cell phones and I don't call DNCs, and you're scrubbing against the federal and state do not call lists for telemarketing purposes, and obviously there's a number of requirements on the state and federal level, but if we're just talking about what this order affected, that's what's contained in the slides that we reviewed today. And obviously the primary hits there were calls to cell phones and making it much more difficult for companies to have confidence that they're complying with the call to cellular phone requirements.
Okay, we do have, there's two things that I want to point out to you. Mark Roth just responded, and he said that the FCC's granting of the DMA petition only applies to members as of the date of the petition.
Okay, thank you, Mark. I appreciate that.
And here's another question that Maudrey just told me is pretty important. What if a caller calls in and the business sends a text message back? So another way to ask, if a business has programmed all inbound calls to send a text message back, is it compliant to have a text go?
Kind of like an auto-response text?
That's what I'm reading it as.
So I guess they'd have to, in order to send a text back, they'd have to have some type of consent to make, no, because it's an inbound call. Yeah, I don't know. That's tough.
I think there's a few issues here. One, that's somewhat similar to, for example, the very, very limited one-time text exemption they provided for an on-demand text, but they were very specific in there that the customer had to have consented to that or had to request that. So in that scenario, they were sending some type of, text inbound to that number with the intent to get a text back. If somebody's just calling an inbound phone number, I would find it difficult to say that they definitively have requested a text back, and then you just get into, if that exemption doesn't apply, was an ATDS used to send that auto-response text? That's a really complicated issue. There's been some court rulings in the past that talked about a response text maybe being initiated by that specific user or the inbound caller, but I don't think that's a settled issue, and I certainly don't think it's settled after this FCC ruling. So it really would come down to what type of equipment was used for that.
Okay, I'm going to ask, go ahead, Michelle, I'm sorry.
There was a question that just came in. Can a third-party collection agency call a mobile device that they get from the loan originator? So, that sweeps in a whole host of issues. The first thing I would say is if you're a third-party collection agency and you are relying on the consent of the loan originator or the original creditor,
Michelle, are you still there? I apologize, everyone. We might have just lost Michelle and Nick. So what we'll do then is any questions that we have that we didn't get to today, we will try and answer them and provide them back to you. But I do want to thank you all for joining our webinar today. We really do hope to see all of you at the PACE 2015 TCPA Washington Summit that's going to be held September 27th through the 29th at the W Hotel. This topic is going to be a huge discussion point. So information for registration and hotel can be found at www.paceassociation.com. Be on the lookout for more information with FCC updates as well. Again, you will all be receiving a copy of the slides later today. And I thank everybody for joining, and have a great day.